And it looks like we are live. Good morning, everybody. Welcome to the Committee on Taxation. We will start with introductions, starting with Senator Pouliot.
Good morning, Senator Matt Pouliot, representing Senate District 15.
And Representative Bickford.
Good morning, Representative Bruce Bickford. I represent House District 63, which is part of Auburn.
Excellent. And Representative Carmichael.
Hey, Senator, I'm Representative Mickey Carmichael. I represent House District 137 with 22 communities in Washington, Hancock, and Penobscot counties.
All right. Representative Collins is not with us. Representative Gramlich.
Good morning. I am Lori Gramlich, and I represent House District 13, soon to be House District 131, which is the lovely seaside community of Old Orchard Beach.
And Representative Hanley.
Good morning. I'm Jeff Hanley. I represent District 87, which are the towns of Piston, Alna, Wiscasset, and
I don't see Representative Stetkis. Representative Matlack.
Good morning. I'm Ann Matlack. I represent House District 92, which includes the communities of Cushing, Thomaston, South Thomaston, St. George, Matinicus, Creehaven, and the Muscle Ridge Islands.
All right. And Representative Perry.
Good morning. Thank you, Mr. Chairman. My name is Joe Perry. I represent part of Orono and part of Bangor in the main house.
And Representative Sachs has another commitment at the moment. She may join us at some point. And Representative Terry.
Good morning. I'm Mo Terry. I represent District 26, the west side of Gorham, and I serve as House Chair of this committee. Welcome, everyone.
All right, and I'm Senator Ben Chipman. I serve as Senate Chair of the committee and represent Senate District 27, which is part of the city of Portland. We also have with us our committee analyst, Julie Jones, and our committee clerk, Lena Braun. We've got several, I guess, public hearings this morning, as well as some work sessions. I actually have another commitment, so I need to take off in a little bit. So I'm going to hand things over to Representative Terry to take things from here.
Actually, Senator, before you leave, would you mind maybe introducing or letting me introduce my bill, and then we can do that real quick, and then I can jump in and take over the gavel.
Excellent. Okay, great.
Okay.
So we'll open up the public hearings, and we will start with Representative Terry.
Okay, good morning. Again, my name is Mo Terry. I represent District 26, the west side of Gorham, and I'm here to present LD 392, an act to amend the tax laws. This was a concept draft that I got, that I kind of put on hold for us as a committee to be able to use if necessary over the course of our couple of years in session so far. And we have found no real need for it. So I'm going to, so this is a bill that does not need to go any further. I would, at anybody's request, entertain someone going right into work session and taking it out to pasture.
Move we go into work session.
Second.
We should close the public hearing first. So any questions for Representative Terry? Seeing none, we have no one to speak in favor, in opposition, or neither for nor against. So we'll now close the public hearing on LD. What was the LD again? I don't have that in front of me.
392.
392. So we're now close the public hearing. And so we have a motion made by Representative Gramlich to go into work session on this bill. And there was a second by, I forget who that was, Representative Matlack.
Yes.
Any discussion? Seeing none, we're now in work session, committee discussion. Seeing none, do we have a motion?
Lena, can you get a Zoom link out to Joel Stetkis? He can't seem to get in.
I just sent him a new one. See
Thank
if
you.
the most recent email.
Sorry, Senator.
Oh, that's okay. And so we have, I think Representative Matlack was making a motion. Representative Matlack?
Yes, I move to ought not to pass.
I'll second it.
We have a motion by Representative Matlack, ought not to pass, seconded by Representative Carmichael. Committee discussion. Seeing none, all those in favor, please signify.
Thank you.
That is unanimous of all members present. We'll close the work session, and I will now hand the virtual gavel over to Representative Terry.
Thank you, Mr. Chair. Okay, I think our next bill up is LD
We built
276.
Penobscot as one of the first.
Somebody's radio's on there. There we go. I believe Representative Barry is not here yet, so we can, I believe, jump right into the next bill, if that's okay, Julie. LD 1937. It is Senator Lucchini's bill, but I believe Senator Sanborn is here to present. I just let her in. Good morning, Senator Sanborn.
Good morning, Representative Terry and members of the Joint Standing Committee on Tax. It's nice to see you all again. Shall I go ahead?
Yeah, after you promised us a little bit of chocolate, I think that's the story.
Indeed. I didn't know if I could get out of it because I'm introducing someone else's bill, but
No,
I
absolutely
promise that when we come back in session in person, I will pay my debts. So I am here today to testify on LD 1937, an act to clarify the exemption from income tax and withholding tax for certain out-of-state suppliers of spirits purchased by the Bureau of Alcoholic Beverages and Lottery Operations, which I'll refer to as BABLO. This bill was originally sponsored by Senator Lucchini this session, but I am here standing in his shoes today. And the bill is quite similar to LD 1993, which was my bill, and then 129th, and which received a unanimous approval of this committee and passed the House and Senate under the gavel in the spring of 2020, but died when we adjourned early due to COVID. As you know, Maine is a control state, meaning that the state is the sole distributor of spirits in the state. And the state monopolizes the purchase and distribution of all spirits acting through BABLO. This monopoly is lucrative and important to the state as it is a growth-centered revenue line item within the state's budget. BABLO receives spirits from manufacturers and suppliers, and BABLO then sells the spirits that it has received at its state-maintained warehouse to retail agency liquor stores. Maine's status as a control state means that only the state of Maine itself, acting through BABLO, can purchase spirits for resale to those agency stores. In its role as the sole purchaser and importer of spirits, BABLO solely and completely manages and controls the state's warehouse located in Kennebec County. This is where all spirits to be sold within the state must be shipped to and stored until they are sold to retail agency liquor stores. As part of this process, BABLO has implemented a mandatory system of delaying transfer of title to the spirits from the manufacturer to BABLO until the spirits are placed on a delivery truck to the retail agency stores. To use the technical term, BABLO requires that the liquor be held in bailment until it is resold to a retail store. These state-required practices, including bailment, may seem mundane in nature and normally would not be the subject of any interest or scrutiny. Recently, however, the Maine Revenue Services has taken the position that out-of-state spirit suppliers, solely because of this structure, should be subject to state income tax liability because they assertedly have an in-state presence based solely on the temporary storage of spirits in the state's warehouse and the state's refusal to take title of the spirits until it has resold them. This position runs counter to the facts. State-required bailment and state-required delay of transfer of title essentially are legal fictions that are imposed by BABLO on out-of-state spirit suppliers. Spirit suppliers, including out-of-state suppliers, cannot have their own warehouse in Maine to sell directly to the retail stores. All storage and sales to retailers must occur through BABLO and as a result of orders placed by BABLO. In a control state like Maine, suppliers cannot legally sell to any party except the state of Maine. Further, once the spirits are received into the state's warehouse, the supplier no longer maintains effective control over the goods. That control and power has been transferred to the state. As a practical matter, the state controls the spirits kept in the warehouse, and the delay of transfer of title is a mere legal fiction created for the convenience of the state. It's unfair to suggest that out-of-state spirit suppliers have an in-state presence sufficient to impose state income tax on them merely because they sell spirits to Maine in accordance with Bablo's requirements. Importantly, however, Maine's attempt to assign state income tax liability on out-of-state spirits suppliers also violates federal law, as interpreted and confirmed by Supreme Court precedent. The law is called PL 86-272. And the federal law, which preempts any state law to the contrary, limits a state's rights to impose taxes on out-of-state companies that approve orders out of state and fill orders from out of state, where their activities are limited to soliciting orders and related or ancillary activities to fulfill such orders. This law, which has been interpreted expansively by the US Supreme Court in the Wrigley case, stands for the proposition that there must be a meaningful in-state presence before a state can impose state income tax on an out-of-state company. LD 1937 seeks to clarify that preemptive federal protection cannot be ignored by state taxing authorities. It also makes clear that out-of-state spirit suppliers who have been instrumental in transforming the state's spirits business into a valuable, publicly owned asset cannot be assessed state income tax merely by selling spirits to the state of Maine and obeying Bablo's directives and requirements when they order spirits from out-of-state suppliers. It's common sense and only fair that out-of-state spirit suppliers can not be forced to surrender their protection under federal and Supreme Court precedent. Thank you for your time. And I'll also note that the bill that you have before you this year is a bit different than my bill last year. In that, or last session, in that it seeks only to clarify this going forward. It doesn't have a retroactivity provision, and there was a retroactivity provision in the bill that this committee passed in the 129th. So that's the distinction I wanted to make there for clarity, and I'd be happy to take any questions that you might have.
Representative Bickford.
Thank you, Madam Chair. Good morning, Senator.
Good morning, nice to see you.
Good to see you. My question is, would you like to see this amended to have retroactivity? Would that, according to, similar to the bill that you had proposed? Or is it not necessarily because of the last court decision?
So I think I'll leave that question up to those who come behind me, who are more directly impacted by the state's effort to seek collection sort of out of the blue for tax revenues going backwards. And there has been a favorable court decision in that, but I understand it may be appealed.
Okay, thank you very much.
Any other questions for Senator Sanborn? Seeing none, thank you very much for your testimony and for presenting the bill. You're welcome to stay as long as you like. We'll keep you on screen. Next up is Jay Hibbard from the Distilled Spirits Council, here to speak in favor of the bill. He'll be with us in just a second. Good morning, Mr. Hibbard. How are you today?
Good morning, Representative Terry. Let me start my video here.
Sure.
There we go. I think we're good. Thank you very much for the opportunity to talk to you this morning. My name is Jay Hibbard. I'm the Senior Vice President of Government Relations for the Distilled Spirits Council of the United States. Senator Sanborn did a great job in the introduction and the explanation of this. The out-of-state spirit suppliers that are doing business with Bablo in the state of Maine are doing it in exactly the way that has been prescribed in statute that they must do in terms of supplying spirits to the state. The relationship they have, as she noted, was only for the fact that they supply the spirits in the manner in which Bablo has directed, and at no time are they actually in possession of it other than, as she referenced, the tax fiction of possession until they go to an agency store. The companies that we represent all do business with the state of Maine, all follow the same prescribed manner of providing spirits to the state. And we would concur that the assertion or the claim that there is a corporate income tax nexus created by virtue of that system is in fact unfair, unjust, and unreasonable. The courts, as she noted, has found repeatedly that in fact that tax relationship does not exist. It runs afoul of the Interstate Income Act of 1959, and I did supply this to you in written testimony, and would be a violation of the Commerce Clause. No other controlled jurisdiction, and there are a number of them, have ever attempted to engage in this sort of tax practice. I think because they also recognize that in order to do business with the state, you're not giving up your constitutional rights. So we would encourage the committee to vote ought to pass on this and clarify in statute that in fact a corporate tax nexus does not exist. And with that, thank you very much for the opportunity to be with you.
Thank you, Mr. Hibbard. Looks like we have a question from Representative Perry.
Thank you. Thank you, Madam Chair. I had a guy who owns a trucking company here in Bangor a number of years ago tell me that the state of New York was essentially hijacking his trucks in New York because he was delivering, moving people into New York. And they said, you're doing business here and you need to pay us income tax. And they'd hold him hostage for, I think he said 10, 20, 30,000 bucks. And he'd just pay it. He didn't want the fight. And he was delivering stuff into New York. But what he said to me was, it's not really my problem because I just take it off my Maine state income tax, because it's apportioned. And it's really, his concern was a bigger problem for the state of Maine, that we're losing revenue that he thought was unjust. I'm curious, is there a real impact on these businesses, or are they, with what they pay to Maine, does that come off somewhere else?
Representative Perry, I can't speak with any authority to New York tax law, so I'm not sure, what his liability or his exposure was in that situation. That just strikes me as a bit odd. The state of Maine has prescribed this is how you have to do business when you supply spirits to the state. And at no point in time has there ever been a corporate income tax liability created by virtue of that. And this was, as Senator Sanborn said, a unique circumstance that said this is very unusual that the state has taken this position. In fact, the Maine Tax Appeals Board found in favor or against the state, if you will, for attempting to impose this tax liability. So I guess that's probably in this case the best I can do, because I can't speak with any authority to the New York tax.
No, I wasn't asking. I was using that as an example. Okay. I guess my question is, and don't take my question as opposition to the bill, that he said, well, I apportion it and it comes off what I pay Maine. If Maine is collecting from these companies, is it costing these companies money, or
Yes.
is it costing some other state money?
No, it is costing these companies money because this is business that they are doing directly with the state of Maine. This is not something that would be offset by some other kind of tax calculation to another state. No, sir.
Excellent. Any other questions for Mr. Hibbard? Seeing none, thank you very much for your testimony. We appreciate you being here.
Thank you very much. I appreciate your time.
You're very welcome. Next up is Peter Angus from Fifth Generation Inc. And then following Mr. Angus will be Stephen Gerlach, also from Fifth Generation. Welcome, Mr. Angus.
Thank you. And good morning, legislators and distinguished members of the Joint Committee on Taxation. My name is Pete Angus, and I'm the Executive Vice President of Tito's Handmade Vodka for the US and Canada. And I appreciate your time today. I'm here to testify in support of LD 1937 that Senator Sanborn outlined so well. The bill enshrines important federal protections that prohibit the state from assessing state income tax against out-of-state spirit suppliers that engage in protected activity within the state and otherwise accept orders and ship from out of state. For your reference, Tito's Handmade Vodka is the original American craft vodka. It's distilled down in Austin, Texas, on the same site that Tito started with 25 years ago. And now, while I'm not an expert on taxation and the laws in every state are different, in my experience, out-of-state manufacturers are not assessed corporate income taxes based on state-required bailment in a control state such as Maine. It's already been referenced, but under the federal law known as PL 86-272, Congress enacted laws that prohibit a state from imposing income tax on out-of-state sellers of goods if their activities are limited to soliciting orders and engaging in activity that's entirely ancillary to the solicitation process. When we look at the state of Maine and how we do business with Maine, we follow their process for selling spirits. And that process includes out-of-state sellers required to honor Bablo's directives. So anything Bablo does, we have to follow their lead. So when they ask for us to ship orders into Bablo, and they hold them in bailment in their warehouse. And under Bablo's requirements, they transfer the title in a delayed fashion only after the truck leaves their warehouse to a retail agency liquor store. Now, the state taxing authorities are trying to use this window of time as justification to tax out-of-state spirit suppliers because they say we have an in-state presence of warehousing in Maine. But this is still protected activity under PL 86-272 because there's no reason for Tito's or any other spirit supplier for that matter to ship spirits to Augusta or to keep spirits in Augusta unless we're fulfilling an order by the state of Maine. We're just adhering to your process. The industry as a whole relies on these protections to conduct its business in a manner so that it does not have to file income tax returns in 50 states. This is simply not required under federal law. And honestly, it would be a logistical nightmare for a small company of ours to have to file state income taxes in 50 states. Maine's attempt to impose tax liability based on out-of-state bailment or delayed transfer of title is well outside the norm of what I've seen in 4 decades in the industry. We don't encounter this in any other state nationally or across the board. So this bill 1937 protects the state assets and it provides clarity to out-of-state suppliers and the Maine taxing authorities that cannot ignore or sidestep the federal protection under PL 86-272. We hope you take these items into consideration and continue to ensure fairness and growth for the state's valuable asset, its spirits business. And I'd be glad to answer any questions you may have.
Does anyone have any questions for Mr. Angus? I just have one, Mr. Angus, if you are aware, I know you said you're not a tax expert, but seeing the business that you're in, are there bailment in a lot of other states that you do business with? Is there bailment?
Madam Chair, there are only bailment in control states where the state acts as the distributor, not in an open state. So in an open state, they will buy product from us and we'll sell it to them in Austin, Texas. They take ownership and away we go. There's only bailment in the other control states, and none of them have gone down the road that Maine is trying to do, where because we hold it in the warehouse before transferring to the stores, they're trying to tax us income tax wise.
Thank you very much. Any other questions for Mr. Angus? All right, seeing none, thank you so much for your testimony. We appreciate you being here all the way from Texas. Next up is Steve Gerlach, also from Fifth Generation. Welcome, Mr. Gerlach.
Good morning. Thank you, Representative Terry. And thank you for welcoming me today. Distinguished legislators and committee members, as Representative Terry mentioned, my name is Steve Gerlach. I'm an attorney practicing tax law at Bernstein Schur for the last 15 years. And I'm also here, like my well-spoken predecessors, to voice my support of LD 1937. Taking a slightly different tack, I think a fair question for any proposed piece of legislation is what specific problem is the Act seeking to fix. The problem, as I see it, is that Maine Revenue Services has recently created a new corporate tax regime without legislative approval. Specifically, it's seeking to impose state income tax on an out-of-state spirit suppliers in violation of federal statutes and U.S. Supreme Court precedent. For decades, out-of-state suppliers and Bablo have engaged in the solicitation of orders, sale of spirits to the state from out of state without any threat of triggering state income tax liability, because federal law protects interstate commerce from state income taxation. Maine Revenue Services now seeks to impose taxes on out-of-state suppliers as if they had an in-state presence, based merely on an activity that is part of the federally protected process for selling spirits to the state of Maine. These federal protections, which I'll describe today, have not been altered or eliminated. Rather, it's just MRS seeking to expand the scope of its taxing authority in violation of those protections and in violation of Maine's Administrative Procedures Act. LD 1937 seeks to restore the federal-state balance by clarifying that out-of-state suppliers that sell spirits to Bablo from out of state remain exempt from state income taxation so long as they engage only in conduct and activities that are protected by the federal authority. Excuse me. So in order to understand the recent attempt to impose that state income tax, as my predecessors have discussed, it's important to note that Maine is a control state. At the distribution level, the only legal purchaser of liquor in the state of Maine is Bablo, the state of Maine itself. Both in-state and out-of-state suppliers sell to Bablo, and then Bablo turns around and sells to retail sellers such as agency liquor stores. Unlike in other industries, there are no direct sales from out-of-state suppliers to retail. And there's only one purchaser of spirits, and that's the state of Maine. The federal preemptive protections that I and my predecessors have been referring to, excuse me, is the Interstate Income Tax Act of 1959, known as Public Law 86-272. And under the Supremacy Clause of the US Constitution, this federal law preempts any conflicting state law. PL 86-272 creates a zone of protected in-state activity that may not be used to subject an out-of-state company to that state's income tax. Specifically, it protects the solicitation of orders for goods inside of a state, so long as those orders are accepted and shipped from out of state, as they are in the case of many out-of-state liquor suppliers. The term solicitation of orders has been developed in a key case before the US Supreme Court called Wisconsin Department of Revenue versus Wrigley. The High Court in 1992 made it clear that protected activity under Public Law 86-272 included not only just asking for orders, but what has been described as missionary sales activity, which is promotional activity. It's extolling the virtues of the product to the ultimate customers, even though the sales are being made to the state. Importantly, the US Supreme Court held that Public Law 86-272 also protects activities that are ancillary to the solicitation process. So activities that are undertaken as part of the fulfillment, such as the state mandated fulfillment activities here enforced by Bablo. These activities are protected by Public Law 86-272, again, so long as the orders are accepted out of state and shipped from out of state. We know this from the Wrigley case. We believe that there's a threat to Bablo. There's a threat to out-of-state liquor suppliers. As noted before, we we have been working together for decades without being assessed state income tax. And this is as it should be. Recently, Maine Revenue Services has sought to retroactively impose income tax on out-of-state suppliers based on its contention, its new contention, that shipments to the bailment warehouse in Augusta creates a sufficient in-state presence to impose the state income tax. Excuse me. Spirits ordered by Bablo are required to be sent to the bailment warehouse where they're stored pending placement on a delivery truck to agency stores. Bablo requires delay in the transfer of title until the spirits are placed on the truck. And based on this requirement, Maine Revenue Services has argued that out-of-state spirit suppliers are storing or selling spirits in Maine, and that the delayed transfer of title waives the protections of Public Law 86-272. This could not be further from the truth. As noted above, the state mandated shipment, storage in Augusta, and all other control requirements imposed by Maine are entirely ancillary to the solicitation process. Put differently, we're required to do it by Bablo, and we wouldn't be engaging in it if we weren't selling liquor to the state of Maine. There's no independent reason for out-of-state suppliers to do this except in connection with those orders. So LD 1937 seeks to make it clear that any delay of transfer of title to Bablo can't be used to impose state income tax on out-of-state spirit suppliers. It should not be open to Bablo and Maine Revenue Services to concurrently order spirits from out of state and then delay acceptance of delivery as a ruse to suggest that out-of-state suppliers are storing spirits on their own account. As already noted, these activities are entirely ancillary to the solicitation of orders in the state. The need for this bill is not based on abstract theories. Recently, for instance, Maine Revenue Services has sought to impose retroactive taxes over a multi-year period starting in 2011 against Tito's Handmade Vodka. To underscore, Maine Revenue Services developed a new tax regime without legislature's approval that imposed it retroactively against the taxpayer. Tito's challenged the action before the Maine Board of Tax Appeals, and the board agreed with Tito's that Tito's in-state activities were part of the solicitation process and could not be used to impose state income tax against the company. I've attached the board's decision to my written testimony. Maine Revenue Services has appealed this decision and the matter remains pending. However, LD 1937 does not look backward. It doesn't look back to this retroactive taxation and will not alter any pending case. Rather, it looks forward to confirm as a matter of law that Maine Revenue Services cannot ignore preemptive federal protections protecting interstate commerce and the continued growth of the state spirits industry. Thank you very much for your time.
Thank you very much, Mr. Gerlach. Looks like we have a question from Representative Perry.
Thank you, Madam Chair. So we heard a lot about control states. Would Tito's have any tax liability in non-control states, or a non-control state where they might not have some other activity like a warehouse or distribution center?
It may. It depends on the state, and it depends on the particular business activities in that state.
If Maine was not a control state, would they have a tax liability here if everything was done in a similar fashion? It just was not a control state. I don't know if you can compare apples to, like, if there's a private warehouse that's going into or something.
I appreciate where you're going with it. It's very hard to say because the entire business model would have to be different, right? If Maine were not a control state, there wouldn't be a bailment warehouse. There would have to be some other way of getting the liquor to the retailers. That may still be entirely being shipped from out of state, or they may have a private warehouse in the state. I think it depends on the particular business model.
Okay, thank you.
Yep.
Other questions for Mr. Gerlach? Seeing none, thank you very much for your time and your testimony, Mr. Gerlach. We appreciate all the legalese for sure. Doesn't look like there's anybody else on my list or in the waiting room to speak in favor of Next up is Mr. D'Alessandro from MRS speaking against the LD. Welcome, Mr. D'Alessandro.
Thank you. Representative Terry, members of the Taxation Committee, good morning. My name is Daniel D'Alessandro, Associate Tax Policy Counsel for the Office of Tax Policy. I'm giving this testimony on behalf of Dr. Allen, the Associate Commissioner for Tax Policy. I'm here today on the request of the administration to testify against LD 1937. The administration recommends that the bill title not refer to this legislation as a clarification of an exemption from income tax when no such exemption exists. Instead, this bill would create a new and unique exemption from income tax for out-of-state liquor companies that is not available to out-of-state companies of any other industry. In doing so, it would put our in-state liquor companies at a competitive disadvantage. This bill implicates federal constitutional and statutory questions of nexus. That is the necessary level of connection between an out-of-state taxpayer and a state necessary for the state to impose tax on the out-of-state taxpayer. These federal laws provide protection against interstate discrimination and unjust application of a state's tax laws on out-of-state taxpayers. They ensure that a state may impose its taxes only on out-of-state companies with constitutionally significant connections with the state. That is, those companies with nexus with the state. This federal body of law stands on its own and cannot be altered by state legislation. Last session, the legislature enacted Public Law 21, 2021, Chapter 181, which included objective thresholds for determining when a corporation has nexus with the state. These thresholds embody federal constitutional principles and explicitly reaffirm the federal protections for out-of-state taxpayers with certain limited connections with the state offered by Federal Public Law 86-272. The bill before you would create the only exception to the state's industry-neutral nexus thresholds. For these reasons, the administrations recommend that references to nexus in the bill be removed and restated to clearly reflect the creation of a new income tax exemption for out-of-state liquor companies. In addition to the concerns outlined above, the administration would like to note the new exemption is retroactive to tax year 2021. If this is the intent, then a retroactivity clause should be added to the bill. Otherwise, a prospective date should be used. MRS has technical concerns with the language the staff can share at the work session. I would like to address a few points raised in earlier testimony. First is the claim that this is a new MRS position. That is not the case. Owning physical property in the state has long been understood to create nexus with the state, and there is widespread and long-standing industry compliance with this requirement. Second is the claim that this violates Federal Public Law 86-272. There is US Supreme Court precedent directly on point, upholding the imposition of tax in similar control and bailment scenarios over a taxpayer's claim of Public Law 86-272 protection. If that Maine Revenue Services does not have the authority to overturn that Supreme Court precedent. And finally, I think it's important to point out that all that Maine state law requires is that a company pay Maine income tax on the income that they earn in Maine. The administration looks forward to working with the committee on the bill. Representatives from MRS will be here for the work session to provide additional information and respond in detail to the committee's questions. And I'd be happy to respond to any questions that you may have now.
Sorry, thank you, Mr. D'Alessandro. It looks like we have a question from Representative Bickford.
Thank you, Madam Chair. Mr. D'Alessandro, can you tell me, first explain to me what nexus means and how you interpret it, and then answer to me what other industries have bailment? What other industries deliver product to Maine, store it in a Maine warehouse, and have to keep title of that product until it's delivered to its destination? What industry follows that same pattern?
Nexus is the connections with the state that an out-of-state corporation or other taxpayer would have. And Nexus is the US federal constitutional limits on how significant those connections would have to be with the state before the state can impose income tax.
Is that such as a warehouse, such as some brick and mortar?
Right. Owning property in the state is a
Okay.
very long-standing and traditional measure that would create nexus.
So do they own property in the state?
Does who own property in the state?
The spirits companies?
I can't talk about any specific taxpayer, but in general, yes. In
Okay.
general, yes, they would.
There are.
Out of state? Out of state spirits that have warehouses in Maine?
There's the property held in bailment. That is property owned in the state within the existing Supreme Court precedent.
Okay, and tell me what other industries, please, have this same issue where they deliver to a main warehouse, not connected to them, and that product stays in their title until it's delivered to the.
There are other industries that use a bailment model. The liquor industry is somewhat unique in that that is required by state regulation. But there are other industries that do use a bailment model, and they do create nexus when they use it.
As required by the state?
Not as required by the state that I'm aware.
All right, so this is the only one that is required by the state.
That I'm aware of, yes.
Okay, thank you very much.
Representative Perry.
Thank you, Madam Chair. Just two quick examples. Walmart obviously has a lot of locations here in Maine and a distribution center, so they'd certainly have nexus, and I'm assuming paying income tax to the state of Maine based on that. But take someone like General Motors. They sell a lot of cars in Maine, but probably don't own any. Well, you said they own the liquor, and unless they're floor planning the lots and don't actually own the cars, would someone like General Motors have to file a state income tax?
So I can't talk about any specific
Sure.
taxpayer, but if you, let's say you shipped cars into the state and maintained title to them until they were sold, that would certainly be property in the state.
Do you know if that's how they do it? If the title remains with the manufacturer till the customer takes delivery?
I'm not sure if that's the case in the car industry.
Thank you.
Any other questions for Mr. D'Alessandro? Seeing none, thank you very much for your time, Mr. D'Alessandro. We appreciate you testifying. There are no other folks here to speak in favor or against. Let's see, what number are we again? LD 1937. And it doesn't look like there's anybody here to speak neither for nor against. So this closes the public hearing on LD 1937. Thank you, Senator Sanborn, for sticking with us today. We appreciate it. Have a great rest of your morning. Last up on our public hearing schedule is LD 276. It is Representative Berry's bill that our own Representative Gramlich is going to present to us for Representative Berry.
Thank you. Thank you, Madam Chair, and my esteemed colleagues on the Taxation Committee. Representative Berry could not be with us today, but he did ask me to present his bill, LD 276, an act to improve and update Maine's tax laws. This is a concept draft pursuant to Joint Rule 208 and would improve and update Maine's tax laws. Representative Berry does not see a need any longer to have this proposed legislation in before our committee, and deems that we do whatever we would like to do with the bill. And that concludes my testimony.
Thank you, Representative Gramlich. Seeing as there is no one here to speak in favor, against, or neither for nor against, nor is there any content to the bill, I would entertain a motion after we close the work session. After we close the public hearing.
I move we close the public hearing.
The public hearing is closed on LD 276.
And I move we ought not to pass on LD 276.
Well, we'll go into work session first.
Thank you.
If that's okay with everybody? Can we get a vote on going straight into work session? It looks
All
unanimous.
set, thank you.
Excellent, thank you. Representative Gramlich, did you say something?
Yes, I did. Thank you, Madam Chair. I move ought not to pass on LD 276.
Looks like seconded perhaps by.
I second the motion.
Thank you. All in favor? Also unanimous, Lena.
Thank you.
Terrific. Thanks, everybody, for that. That concludes our public hearings for this morning. We have a work session scheduled for 11 o'clock for one bill, I believe. Is that correct, Julie? Yep. So we can all take a 11-minute break and join us back here. Representative Hanley, did you have something to say, or your hand is still up?
Madam Chair, yeah, I noticed that during the hearings, unable to chat with you.
Oh,
Is
apologies.
that function disabled for a reason?
You know, I cannot tell you that. Lena may be able to tell us that, though.
My concern was that we're not observing a 3-minute clock during the testimony.
Yes.
We might want to look at that.
Yeah. We for sure, Representative Hanley, let folks know that ahead of time, especially when we have a very long schedule of attendees. Generally speaking, when there's just a few, we try to give people a little bit more time, but I appreciate that and was also concerned with that myself.
Okay.
Yeah.
Thank you.
Yes, thank you. Thank you for bringing that up. I appreciate it. And Lena, if we do have a chat function, I'm not sure by the.
I can't find it. I
Yeah.
don't know why we don't have one. We're supposed to have one.
Okay.
I'll figure it out and let you guys know.
That sounds terrific.
All right.
Great. So,
Representative Terry,
yes, Senator Pouliot.
we have a briefing on the budget for leadership at 11, so I'm not going to be coming back on until that's done.
Okay, I think you're gonna be okay. Oh, no, we can't vote without a senator.
Kidman said that he thought he would be back on, but I don't know.
Yeah, he did say that he'd be back by 11 too. So we'll go through, we'll keep our fingers crossed. How's that sound?
I mean, as soon as we're done, I don't know how long this briefing is going to take, then I'll hop back on.
The work session will take all of, I would imagine, 6 minutes tops.
Okay.
Got a little insider information, which we'll all find out about in a
Well,
minute.
probably what I'll do then is I'll hop on that thing at 11 and just let them know that I need to come back so that you guys can be doing at least the work session and then hop back, I guess. I don't know.
That would be great, Senator. We would appreciate that very much.
Okay.
Okay, terrific. Thanks all. We'll see you in 10. Hey, everyone. I see Senator Maximum is not in yet, so I'm gonna jump off for a second, make sure she can get here quickly. All right. Everybody back. Looks like we've got 8 of us here, and Senator Maximum is here as well. So why don't we jump right back in? Julie, whenever you are ready.
Okay, I'm going to see if I can bring up the chart. Okay, you got the chart?
We
do. Today's work session is on LD 1689, Senator Maximum's bill carried over from last session. The title is an act to ensure equity in the clean energy economy by providing a limited tax exemption for certain clean energy infrastructure projects. What the bill does is to provide for either a sales tax, refund, or exemption to a person who purchases machinery or equipment for direct use in the development and construction of a clean energy product. The exemption or refund would be equal to 75% of the sales tax otherwise due. So not the entire sales tax, but 75%. Its basic structure is a refund. However, the bill does have provisions that provide that if a person engaged in the construction and development of these projects can demonstrate to the Department of Labor that it's qualified, then they can get reimbursement from the state, or they may be able to upfront be able to qualify for a sales tax exemption so they don't have to pay when they purchase it. The bill is somewhat complicated in terms of its administrative provisions in determining who would be eligible. The clean energy product is defined as the development or construction of infrastructure for the generation, storage, transformation, transmission, or transmission of electricity generated using fuel cells, wind, solar cells, biomass, tides or waves, geothermal resources, or technology that converts otherwise lost energy from exhaust. And as I mentioned, the person wanting to claim the exemption or refund would have to be certified by the Department of Labor. They'd have to demonstrate that it's a clean energy project, that it results in meaningful economic impact on an overburdened community, which is basically a low-income community, although the definition is a little bit more complicated than that. That it supports local manufacturing, is developed under a community benefits agreement or project labor agreement. so those, in order to be eligible to receive the refund or exemption, they would have to meet those requirements. The bill also has a provision in it requiring the Governor's Office of Policy, Innovation and the Future to develop a detailed supply chain manufacturing assessment. I have no idea what that is, of how the state can support existing manufacturing and attract additional manufacturing associated with renewable energy industries, including but not limited to heat pumps, solar, offshore wind, hydrogen, and tidal power. As you can tell from the number on the bill, it was printed relatively late in the legislative process last year. It did have a public hearing last year. Maine Revenue Services, in their testimony at the public hearing, indicated that they had numerous technical concerns with the way the exemption was set up. And they can probably speak to that. I think, I'm quite sure they're here. Maine Revenue Services, in fact, recommended that you carry it over until this year. I don't know if that's why you did, but the committee voted in May last year to carry it over to this year for further work. I myself have not heard whether further work has been done since last year with regard to this bill, but if the sponsor's here, I'm sure she would know, or perhaps Maine Revenue Services might know, but I have not heard myself.
And the sponsor is here. So welcome, Senator Maximum.
Thank you so much, Representative Terry. Hello, everybody. I'm so grateful for you taking this up again. I'm actually going to ask that this bill is an ONTP today. We did meet with Maine Revenue Services, and I think there's a lot of good work to be done in this arena, but we just didn't have the capacity or the time to be able to really figure out the nuances in the specific places where we could really incentivize this kind of work. So simple one for you.
Easy breezy. Representative Bickford.
Make a motion not to pass.
Is there a second? Representative Hanley. Thank you. Senator Maximum, thank you very much for all the work you did, and we appreciate you coming in and talking to us about it. Appreciate it. Okay.
We need Sean Roderick back.
I'm sorry. Yes, we need Sean Roderick back. Yes. I just texted the senators and asked them to jump in so we can take a vote on that. We'll wait just a sec or so. In the meantime, while we are waiting, Julie, do we have anything else that we're going to talk about today?
Not that I'm aware of.
Okay. We had some questions, I think Representative Carmichael. Oh no, I guess we have to wait for the amendment to come in to bring up a bill that that was previously voted on. I think we need to do that. So Mickey, let's hold off for just a sec.
Okay.
See if we can get a senator to jump on. Hi, Julie.
I only wanted to mention, in case you need it, that I looked at the joint rules, and the joint rules say that you are allowed to vote without the president of this, excuse me, without the presence of a senator if you get permission from the president of the Senate. I don't know if you want to try to track down that option, but that is a possibility.
That would be great. Lena, would you mind reaching out up there and seeing if that's okay?
Yes, I will. I was on mute, sorry.
That's okay, thank you. Seeing as that they're in a leadership meeting, my guess is the Senate president is in that, but maybe he has a magic wand. Oh, it looks like actually Senator Libby might be able to jump on too. Great. Senator, thank you so much for coming in. We appreciate it. Lena, looks like we're ready to take a vote whenever.
I just saw that. Ready.
So Senator Libby, to bring you up to speed on the fly, we are taking a vote. The motion has been made ought not to pass on LD 1689, which is Senator Maximum's bill, which she asked for us to vote ought not to pass. They're still working on some of the things that it will take to make that bill work. So that being said, all those in favor of ought not to pass, please raise your hand.
Thank you.
Got it, Lena?
Yes.
Terrific. Thank you so much. Appreciate it. And thank you, Senator. I know you've got kiddos to take care of over there. All right. Julie, anything else for us for today?
No, although it occurred to me, perhaps we should just mention in case anybody tuned in and didn't catch that, because we had originally scheduled LD 1195 for a work session today. However, that previous to today, that was canceled for today and moved to next Thursday, February 24th is when it's on the schedule now.
Correct. I believe Senator Chipman was working with the bill sponsor for that bill to finalize a couple of things. Representative Bickford.
Thank you, Madam Chair. Was there a bill that we were going to reconsider today?
That's what I was wondering. Is that today? Can we do that today? Lena, do you have LD 1129 in front of you?
I can get it.
Okay.
Unless you would rather do that Thursday.
We'll leave it up to Representative Carmichael.
I think maybe it'd be better to do it Thursday. We can prepare for it a little better.
Okay, terrific. That's great. If you could just get in touch with Lena and make sure that she's got that ready for you on Thursday, okay?
Yep.
Great. All right, terrific. We are good to go. Thanks very much, everybody. Appreciate our weird day today. Have a good one. We'll see you. Well, we'll see you in person tomorrow and then back on screen on Thursday. Bye-bye.
Bye.